Good afternoon. My name is Alena Shautsova. I'm an immigration attorney from Brooklyn, New York. In today's live Facebook presentation, I would like to provide you with some recent updates regarding recent immigration news. But first of all, I hope you're all safe. I'm from New York. I'm in New York, and right now we have tropical storm going on, and the weather outside is absolutely crazy. But it's in New York, so wherever you are, hope you are safe. So let me talk now about some good news in immigration, really good news. So what's happening, first of all, is that for those of you who ever had J1 or F1 status and that status lapsed, you may be interested in the news that the government dropped its appeal. What happened is that at some point, President Trump's administration decided that those who are falling out of duration of status will automatically start to acquire unlawful presence time. And it's relevant for such visas as F1 visa, F2 visa, J1 visa, most commonly. People who are entering the United States on those visas are usually admitted for what's called D/S, or duration of status. So when you're admitted for duration of status, if you stop going to school or you violate your status, you not automatically would start accumulate unlawful presence, those illegal days that are relevant for unlawful presence bars. Okay, it's different, for example, if a person came in a B status, tourist status. For example, person crosses the border in the B status expires in 3 months. Day number 31, person starts accumulating unlawful presence time if the person didn't leave the United States and didn't try to fix their status some other way. So for those who were admitted on duration of status, that was different, okay? People did not have unlawful presence. But President Trump administration decided that they're going to change that, and the people will automatically start accumulating unlawful presence time, even if they were admitted for duration of status. So there was a lawsuit filed, okay? There was a lawsuit filed, and federal judge from a district court decided that, no, it cannot be. The rule is the rule, and if a person is admitted for duration of status, then the person cannot be said to accumulate unlawful presence. Why? It's because there is no point in time from which we can ascertain that the person actually became without status, because it was DS designation, right? So there was a ruling, and then the government filed the appeal. In the meantime, the policy was that unlawful presence would not be counted for those who just stopped being in status. So finally, the government decided to drop the appeal. All right, they dropped the appeal, and the policy reverted back as it always was, that if you simply overstayed your F1 or J1 visa, M1 I believe as well, for duration of status, you will not be automatically accumulating unlawful presence. You will if, for example, you try to change your status and the government said no, you cannot change your status, or if the government sent you a letter saying that, hello, you overstayed and now you have to leave, and your unlawful presence starts, and removal proceedings were started against you. But if you just overstayed, you will not have that unlawful presence. Why is it relevant? Why is it important? It's important because if a person does not have unlawful presence status, unlawful presence days, a person can leave the United States, get an immigrant visa, and come back, okay? If the person is said to have unlawful presence days, then the person cannot just do that. The person will need unlawful presence waiver to come back, okay? If the person did not serve enough time outside of the United States. So it's a very good news, right? I wasn't following the litigation closely. I'm not sure what was the reasoning behind the government's action, but it's a good news. Now the policy is that if you stayed F1, M1, or J1, you, person will not have automatically accumulation of unlawful presence. So that's one news. Second news, You may be aware about presidential proclamations barring entry for certain immigrants and non-immigrants, including DV lottery potential immigrants. So the lawsuit was filed to challenge those proclamations, and the plaintiffs in the lawsuit filed what's called preliminary injunction. If granted, it will stop the proclamations, and it will allow many immigrants, including, for example, parents of the United States citizens, husbands and wives of green card holders, and DV lottery people to enter the United States and not to lose their DV lottery status. All right, so there is no specific decision on this preliminary injunction yet. It was just filed. Of course, the government is going to fight it. They're going to present their arguments as to why it should not be granted. But we're all waiting. At least there is some hope that, especially DV lottery holders, okay, those who won DV lottery, who had the interview scheduled, who made plans but couldn't, the interview was canceled, then now they have some hope that they may be able to actually use that one DV lottery. It's very important. And we have a third very good news is that I had a video on that, but let me just talk about it a little bit in more detail. The public charge rule suspended, okay? If you're filing your adjustment of status documents starting from July 29th, you do not have to attach Form I-944 and exhibits to that form. Plus, if you already filed your documents before, the government is not going to consider those filings related to Form I-944, not the whole filing, just the portion that related to the new rules about public charge. All right, so if you were preparing your adjustment of status, now is a good time to file your case within this window that we have, and hopefully your case will be adjudicated within the time frame before the public charge rule will become active again, and it probably will help many people to become permanent residents. I hope so, because the public charge, of course, it's very hard to meet that requirement of being totally self-sufficient during the time of the pandemic, right? It's a very unprecedented times of pandemic. So these are the good news, if you guys have any questions, I'll be happy to answer them. Let me see. Do you know when the USCIS offices will be open? Well, some of them are already open. They do require social distancing rules to be observed if you're coming in. I know that some people already started receiving appointment notices, notices for fingerprints. So it depends, I guess, on your location. In New York, I know that they are open, just a matter of, I guess, how they will be slowly, they will be rescheduling everybody, because they cannot, obviously at this times, they cannot have the same capacity to process everyone as it used to be, right? Because of the COVID situation. They cannot invite 100 people in. They can invite only, let's say, I assume 25 people in, and that's what slows the place down. But they're open. Alena, are you democratic? What kind of question is that? Let's have questions about immigration, guys. If you are going through with your papers work, but came with a visa, can you adjust status? If you have a legal entry and now you have grounds for adjustment of status, let's say because immediate relative filed for you, well, it means that unlawful presence time is not going to be a problem for you, but you may be otherwise barred. You may have to have waivers. Let's say there was I'm not talking about specifically you, of course, but a person may have a fraud issue in their case, a person may have some other issues. Maybe there was a criminal conviction, right? So when we talk about adjustment of status, and I have a good article on my website about that, you need to look into various aspects of a person's immigration and criminal history, okay? And if all checks out, then a person is adjustable. When immigration will be open for the interview again, some immigration offices are already open for the interview, okay? We just received news that immigration court in New York is going to delay their hearings for non-detained people again, okay? I believe through August 21st. Right now, there is an announcement, potentially even later. In New Jersey, immigration court is partially open for non-detained hearings, and actually, there are people who are trying to sue them for that. So, some, depending on where you are at, some of the offices already were opened. Already married with Americans, so I came legally. I need information. If you, okay, there are plenty of information online. There are plenty of information available on at uscis.gov website, right? I post a lot of articles about adjustment of status based on marriage on my website, www.shautsova.com. You're welcome to check it out just to see what the process is going to be like. But basically, the process consists of two parts. One part is that your spouse is petitioning for you, and it's done simultaneously for you to be recognized as the person's as a spouse's immediate relative for the immigration. And the second part of the process is that you're filing for your green card, showing that there are no obstacles for you to receive the green card, and those forms are filed simultaneously. Is it true if you work in fast food, you will get green card for 1 year? I don't think so. I don't believe so. I know that there were some proposed laws, okay, to give certain workers in certain industries some certain privileges, but so far nothing has changed. I applied for permanent green card since last July. How long does it take? Well, it depends, I guess, based on what you filed. You should ask your attorney if you received any requests for more evidence, regularly. Also depends on if you're in immigration court, ever been in immigration court. It usually takes about a year if you are being sponsored by an immediate relative. All right, let me see. How many more years I have to wait to get the U visa? My husband and myself applied in 2016. We went to the fingerprints, but still not heard anything. It takes a long time for the U visas to be processed right now. And yes, I've heard that some cases have been pending for 4 years, right? But as long as you, God forbid, receive denial, I think there is always hope that at some point they will decide your petition. I believe they've been challenged for those delays too. The government was sued. There was a lawsuit related to the U visas. So, we're going to see. Of course, you should discuss it with your attorney. There are certain avenues that you can use to try to get the decision faster, but it depends on the situation. Hello, madam. I have case U visa. I'm waiting for work permit 100 days. How long does it take? It takes, as I said, long time for the U visas, right? Very long time. If you're waiting for the work permit based on some other category, let's say C9, because you filed for adjustment of status after you had a U visa, well, it probably should take no more than 4 to 5 months, I would say. But it's hard for me to give accurate estimates, especially right now during the COVID. And also I've noticed, there are different cases and different situations. Like you may have heard that some people didn't receive their work permits or green cards, and some people did, okay? So it depends, I guess. It's hard for me to predict what's going to happen. IDV 2020 winners have a chance to get an interview. I just stated that they may have a chance, okay? Because there is a lawsuit where plaintiffs filed for DV lottery winners to have that chance, and the judge is going to decide that soon. I think this within the next month we will know, okay? But we'll see. Hi, I applied 290B. It's been 1 year and still not get my decision. It is true that 290Bs may be pending for a very long time. Okay, motions to reopen or appeals, they are pending for a long time. My case U visa after 5 years got approved. See, somebody commented that it took 5 years to receive a decision on the U visa case. Hey, how do I adjust my 2 years conditional green card status? Well, you need to file for a petition to remove conditions. I believe you already asked that question. It's Form I-751, okay, that you need to file. And the form can be filed at uscis.gov. And the grounds for the removal of the condition, of course, you're going to choose applicable to your situation. If it's a joint filing or it's a single filing with a waiver, depending on what happened in your case. All right, guys, thank you very much for joining me today. It was very nice to see all of you. I'm happy to be able to answer some of your questions. And, you know, as always, you can find more information about various immigration topics, how to handle various immigration situations at our website, www.shautsova.com. Thank you very much.